I am Ms. Aditi Panda from the Department of Computer Science and Engineering, Shiksha Anusandhan University. Welcome to the 40th weekly webinar, weekly academic lecture of Shiksha Anusandhan University. Today we have with us Mr. Biswaranjan Acharya from KIIT University. He's a senior member of IEEE. I would like to start his introduction like that. He's an academic currently associated with KIIT, and he is pursuing his PhD in computer applications from VSSUT Burla. He has received his MCA degree in 2009 from IGNOU, New Delhi, and MTech in computer science and engineering in 2012 from DPUT, Odisha, India. He is also associated with various educational and research societies like IEEE, IACSIT, CSI, IAENG, and ISC. He has industry experience as a software engineer. He is also currently working on research in multiprocessor scheduling, along with fields like data analytics, computer vision, machine learning, and IoT. He has published 40 research articles in various peer-reviewed journals indexed by Scopus, SCI, Web of Science journals. He has also edited 6 books as co-editor and authored 2 of them as co-author. And most importantly, he has 50 patents to his credit, more than 50 patents to his credit. And this is why he's going to talk about the importance of patent and intellectual property in academics. So you may please take the screen, share your screen, and start.
Thank you so much, madam. Is it visible? Screen is visible now?
So we can see that you have shared, but the PPT is not visible. Yes, now it's visible, sir.
Okay, thank you. Very good afternoon, all of you here present here. Thank you, Department of Computer Science and Engineering, arranging such a nice session, that is SOA weekly academic lectures. And very thankful also I am to give a opportunity to share my thoughts in this type of session. Thank you, Dr. Professor Devhuti Mishra, Madam, HOD and convener of this weekly academic lecture, and thank you, Dr. Aditi Ms. Panda, Madam, coordinator, and all organizer team and special students. Thank you all. I am trying to explain intellectual property and patent in academics in my little knowledge. I try to explain. Hope you will learn something, or you can ask any doubt also. This is simple, a picture, drop-off cap. Why actually I put this picture? Necessity is the mother of invention. When first phase of coronavirus and first phase of lockdown, the drop down, normally it drop of cap normally 2-3 rupees, but when shutdown started, it goes up to 10 rupees because of shortage in markets. After production in Odisha, I am talking about this price actually in Odisha, especially Bhubaneswar. When in Bhubaneswar actually it started manufacturing, it again comes to normal 3 to 5 rupees. Again, I am taking two actually vaccination process actually in India, that is COVID-19 vaccine in India. This is generally two vaccination vaccine actually two types of vaccine in India actually, that is Covishield and another is Covaxin. Covaxin manufactured by Indian government by collaboration with India. Covaxin actually Bharat Biotech with collaboration with Indian Council of Medical Research, ICMR. Another huge amount of Covaxin given by Oxford AstraZeneca, that is Covishield. Why I am telling actually two types of vaccines here? Because whenever no one know what is a coronavirus and what will be vaccination process, whenever we suffer this situation, immediately the manufacturer or researcher develop this vaccination and also manufacture. What is, first I would like to explain what is IP by intellectual property. Property generally, all of it, we know that is tangible, intangible. Tangible also known movable, immovable, movable in a table, scooter, any car, any properties. On immovable also, that is house, land, property. Another type of property that is intangible, that is one of intangible properties, intellectual property, that is patent, copyright. We'll go to details. What are the different types of IP? IP evolutions, that is intellect, then property, then right. We divided actually three types. One is idea. Intellect, we can say it is idea. Then property, whenever it is form of expression. If intellect or idea into expression, that is property. Then right, copyright, patent, trademark, design, trade secret. When we form in copyright or patent, we will get in copyright form, patent form, trademark, that is our right. Idea expression, if we write something, that is expression. Not only write, we can, one song also can be copyright, that is singing, any expression. Idea innovation, that invention, that patent. Idea quality plus identity, then trademark. Idea appearance, design. We will explain actually one by one. First, we know what are the different types of IP. Idea, keep confidential, no disclosure, then trade secret. Intellectual property and intellectual property right. Already we discussed actually what is intellectual, then property, then right. When idea into expression, that is property. Again, whenever we get legal right, that it is the right, property right. Intellectual property is that which result from a creation of intellect in institution, scientific, literally, or artistic. Later also, I explain actually better in figure. Intellectual property right are the exclusive right granted to the owner of the said property for its commercial explanation, subject of the provision of national law and international agreement, with view of to reward the intellectual creativity. Granted by national laws and international agreement to the developer or to the creator, then it is known as intellectual property. Intellectual property is ideas, information and knowledge. Intellectuals because it's creative output, property because it views as tradable commodity. The IP can be tradable, so it is a property. IP and IPR. IPR specifically legal right which protect the owners of IP. It in schools, so different types of IP, that is patent, copyright, also database. We can also database right, design right, trademark, and know-how. IPR can be traded and used to generate income also. A product or service can be protected in multiple ways, or it can be combination of more than one. Same thing we represent in different form actually. It is patent, new invention. If new invention, we can go for patents. What is why we need actually patents? Stops other from making, selling, using the invention. Trademark, product identifiers, stop others from using product names, logo, and jingles. Registered design, external appearance. I will share actually. I developed actually two design also. One is vegetable and fruit washer. In the time of COVID also, we thought actually how household people are wash their vegetable and fruits without touching any human body, any human hand. So we can design actually one design that is vegetable and fruit washer. Know-how, copyright also will explain. The know-how can be licensed to others to generate revenue. Copyright, original creativity or artistic form, same thing, stop others from using writing and literally work, art, photography, film, TV, music, etc. Database rights, database. If we design one or we keep one database, we can also give right to others to use by paying some rented like this. Can be licensed to others to generate revenue. Multiple layers can be used simultaneously for a product. What is copyright? Copyright is a protection offered to the work created by the authors of literally dramatic, artistic, musical works, producers of cinematography films and sound recordings. A copyright protects particular manner in which work, contents and ideas are expressed. It is bundle of right including right, reproduction, communication to public, adoption, translation of work. Same thing, copyrights protects to literally music, sculpture, painting, lectures, anything, choreographic, works, map, technical drawing, translation. Protection also extend to multimedia production also. Then main criteria of the production, the under work or the work must be novel, the original. Same thing we represented one particular machine represented in four different forms. In 46, the computer or computing device like this. In 46, whenever computer came, in the time of Second World War. Generally, in Second World War time, many invention came. In also, we suffering that pandemic in this during now video lecturing or online, the online classes is now is normal because of pandemic. We are habituated with online classes. Here we taken actually same computer in 1946, and then 1964, then 1981, then 1991, laptop came. Why I kept this one? This is the invention, then innovation. Invention first came, then innovation, then multiple different form of a same thing. That is invention, then innovation. The invention is the generation of an idea that can be resolve a technical problem. Innovation, the innovation can be considered as a interactive process that has place in a different phase of the product construction. Same 1946 to 2000 or 2020. What is the form of different computer? Innovation. In economic term, innovation describes development and application of idea and technology that improve goods and service or make their production more efficient. Improve good and service or make their production more efficient. That is innovation. Example, same actually, we can take an example of computer system, or to take an example of steam engine. In 18th century, the steam engine came into existence to use in factories, enabling mass production, and they revolutionized transport with the railways. Then came into used in railway system. More recently, information technology transformed the way companies produce and sell their goods and services, while opening up new market and new business model using nowadays different IT technology. Patent. Already we discussed what is IP, then IPR. Four things, actually combination of four things for a patent. So a grant of exclusive legal right by government to the applicant for the disclosed invention for a limited period, which is enforced only in the country where patent granted, geographical region. First one is legal right by government of India to the inventor or to the applicant for his or her disclosed invention for a certain period of time, and it has a geographical boundary. The patent can be treated on its territory only, which is enforced only in the country who is the patent granted. Agreement generally standard patent in worldwide, actually it is 20 years. Inventor or assign satisfy when we can apply, or inventor can granted its claim to a patent, it has satisfy some rules, that is novelty, inventive strength, and particular on applicability. Social applicability must be. That is patent system. Patent is interest. Both are actually balanced. Patent protection to the inventor. Inventor can protected by patenting. Then public interest, it has some social impact, and disclosure of the invention of IPO, intellectual property office. It is satisfy the disclosure rule, that is by prior art search, it must be comes under disclosure, that cannot be disclosed before. Limited period, already told, actually 20 years general standard patent. Some countries giving a utility patent and innovation patent, that is 8 year, 10 year. Australia gives actually 8 years. German giving actually 10 years, that is innovation patents, that is utility patents. Other other standard patents has 20 years. Another copyright, actually copyright is lifelong, or that is 60 years, but standard patent is 20 years. Limited periods means after expiry, patent come into public domain. Condition: full disclosure of the invention by the applicant, must teach others how to make and use the invention. In the examination phase also, whenever filing, the inventor must be explained each step by step, what is the procedure, what is the social impact, what right he has to apply. This is the most teach others how to make, use the invention. Must disclose the best way of making and using the invention. Geographic reach. Territory, particular territory. So patent right are limited territoriality. The Indian patent is limited to territory of India. An Indian patent cannot be enforced outside India. Criteria for patentability. Novel, it must be novel, novelty, then applicable. It has some social applicability, social impact. Inventive, it must be inventive, enabling. Never been disclosed or made public before the application, that is prior art, priority art date. Involved in inventive state, not obvious to somebody skilled in the art. Applicable, capable of commercial application, that must be applicability or can be commerciality viability, so it can be granted to the owner. Enabling, sufficiently describe the invention for others to practice it, or each step must be explainable. What is prior art? Prior art, actually, before filing a patent, comes to prior art search, because it must be novel. So prior art search before filing, it must be goes to prior art search, different searching technology or searching database. From different searching database we can search anything. Priority art is any evidence that your invention is already known, that informs on the novelty or invention. This includes anything publicly disclosed about your sorry, that must sometimes maybe technique known, but utility or different application can be a new something different. One technique already known, but different application and something changes in a particular technique, we can also invent a different thing, different product. Rules for patent searching. Google patent, we can freely search actually through Google patent. Escape net, there is patent scope also another. Paid also, used professional can use actually paid searching engine, that is Pantasnop or Inography. Field of invention. Different, any invention can take place in any field, that is electronics, computer application, communication, chemistry, biotechnology, nanotechnology, Ayurveda, Siddha, any form. That means a invention can be a needle to satellite, anything can be. Objective is granting, objective of patent granting as a monetary reward for revealing technological innovation, monetary gain or commercialization, feasibility, to provide improved technology at affordable cost to public with return of investment made for the development. Improved technology, to provide improved technology with affordable cost effective. Cost effective, portable also come under That is the one features of your main invention, but it must be cost effective. To promote, invent around the concept and article. From literally or literature, we can invent something, product that can be. To facilitate technical advancement and economic growth to a country, resulting in cheaper and better products in a high life standard. To facilitate technical advancement. To encourage commercial evaluation of the invention. To its generally the cost, financial benefit to the inventor. Advantages, avoids, what is the advantages? Avoid duplication of research. If you write your invention, the publicly available also, this this technique or this product developed under you, avoid duplication, keeps abreast with latest development in different field of technology, help industry to improve existing technology to produce cheaper and better product, serves as an indicator of achievement in R&D, institution and ability to individual researcher. These are the advantages. Patentable subject matter. It is related to process or product or both. Both can be in. For example, in products, smart waste bin, smart bin, for example, smart bin, that is a product. In actual process, that the mechanism is known as process. For product, smart bin, the design, we can take also a design registered. What are the bin structure? That is the design. For design, we have to give actually 7 side of that design. That more protect for your design actually. If any industry use this your structure, that must be prior permission by taking permission. Be new, something as new, involve in inventive steps. Already one existing system can be modified after invention. Be capable industrial application, not fall under section 3 and 4. Some medical related or natural law cannot be under patentable, so not fall under section 4 and section 3 and 4. I'll give actually in a slide also. New means already we know what is new, published in India or elsewhere. That now must not be published in India or elsewhere, in prior public knowledge or prior public use within India. Some goods are already used, but new innovative steps are used, can be patentable. So the product or process must know, people know, claimed in any specification in India. Everything made available to the public by means of written description or oral description or in any other way before, by use or in use state of act, before the filing date of the application. That is prior art search. Inventive step. What is the inventive step? A feature of invention that is involves technical advance as compared to the existing knowledge. Has economic significance or both. Make the invention not obvious to a person skilled in art. Would a person with ordinary skills have thought the alleged invention? If answer is no, then invention can be. Cell phone. For a product, particular product, there are many actually things required. Many concepts are patentable. Different parts of different functionality are different, comes under different category also. Working mechanism patentable. Shape, like I told earlier one example, that is smart bin or smart dustbin. For bin, particular bin, we can give a new structure, that is shape, design, name, trademark, that is Motorola or जो भी Samsung iPhone S5, PS7, that is model, that is trademark. Manual, copyright. The literally explanation of the working procedure or mechanism, that is copyright. Another example we can take actually pressure cooker. Constitutional feature, that is patent right. Design, actually the structure, that is design. Name, logo, the any company actually available for pressure, prestige or anything, that is name, logo, that is trademark. Copyright, that booklet or catalog is the copyright. Industrial application means invention is capable of being made, used in any kind of industry. That means it can get in form of product, industrial application. Patent protection is particularly critical for development of pharmaceutical. Pharmaceutical actually different health related issue. So it is a risk. Development of new therapeutic vaccine product is particularly high risk activity. Time frame are long. Financial investment is very high. Clinical trials are very difficult. Probability of failure is high. That is life risks. So it is very riskful actually to patent. For particular registered laboratory can do this only. Individual cannot. Patent protection of financial products is necessary before companies will take the risk and make the investment. Final products. Patent protection of the final product necessary. India's contribution science and technology from ancient to modern actually. Still Indians are something, Indian are traditionally used, but not filed patent. So many things nowadays patent right in the hand of Western countries. Still, many things we have contributed to the world. India has been contributing in the field of science and technology since ancient times. Even today, what can we term as traditional knowledge is actually based on scientific reasoning. Pre-independence in history of scientific discovery or development, India dates back to Vedic era. Aryabhatta, the famous mathematician of Vedic era, invented zero. Aryabhatta invented zero. It is believed that ancient Indian scholars have developed geometric theorem before Pythagoras has made them popular. Square, rectangular, circle, triangle, fraction, all are invention by Indian also. It is their origin in Vedic literature also. We find that in Vedic literature, some are stated have been known as the early 1500 BC. The decimal system was already in use of during Harappan civilization. This evidence in their use of weight and measure. Astronomy and metaphysics are all described in the Rig Veda, an ancient Hindu text of Vedic era. From the complex layout of Harappan towns to the existence of the iron pillar in Delhi, it is evident that India's indigenous technology had been very sophisticated. Water management also, water crisis now will be actually. But Indians are developing water management technique even before Harappan time. Well, ponds, lake, dam and canals have been constructed within advanced technology throughout the historic timeline of Indian civilization. Water has been used storage, drinking and purpose of irrigation. Reservation of water is important. Nowadays, very scarce it will be happen in future. It is estimated that even today there are more than million of man-made ponds and lakes in India. In India, iron and steel. Iron and steel have literally been pillars of modern civilization. Ancient India is pioneer in developing technology of producing rust-free iron. This metal from India was famous in contemporary Europe for sword making. The famous iron pillar of Delhi, Qutub Minar's pillar, actually. This is a testimony that technology which almost rust-free even today. Farming technology, Indian farming technology was mostly indigenous, developed and was ahead of its time. It includes soil testing, crop rotation methods, irrigation plants, application of eco-friendly pesticides and fertilizer, storage method of crops, etc. We developed actually one things here on-site automated soil testing. That is on examination stage actually final examination. It is actually date of filing Acris 31st October 2020. Also request for examination same after November 2nd November 2020 publication. So also it is published in 1 month, but still it is in examination process. Two round query also we solved, still not granted. Physics. The concept of atom can be traced at Vedic times. Physics from Vedic actually we used. Actually. The material world was divided into 5 elements, namely Prithvi, fire, Prithvi, Agni, Vayu, Jala, and Akash. Parjavarana, actually it is come under Parjavarana. Now also from by sponsoring different ministry of government of India, now this Parjavarana work is going on in ITER on your university also December 2022 on Vayu, on air pollution, one international conference will be held, that is sponsored by space departments, I think that will be. Paramanu, beyond atom, was considered to be the smallest particle which cannot be divided further. Nuclear energy produced today getting the same. Medicine and surgery, Ayurveda. Life knowledge actually, Ayurveda, probably the oldest structure system medical science in the world actually. Proper knowledge about various eliminate disease system, diagnosis, care is the basic Ayurveda. Many scholars, Chakra, Sushruta have made invaluable contribution to the Ayurveda. It are the different contribution of Indian, ancient Indian to modern Indian actually, that it will come to what are not patentable. Section 3, actually not patentable invention. Fabulous invention contrary to well-established natural law. Natural law against, we cannot be established this, so it cannot be patentable. Section 3, commercial explanation of primary use of invention, which could be public or morality, public order or morality, contrary to public order. Or example, device or method for committing theft, burglary, human cloning, that cannot be patentable. Causes serious prejudice, health, human, animal, plant life, or to the environment. Method or device for adulteration of food, it cannot be patentable. Mere discovery of scientific principle or formulation of abstract theory, discovery any living thing, discovery of non-living substance occurring in nature, it cannot be patentable. Newton's law, Darwin's theory, discovery of animal, discovery of natural gas or minerals, it cannot be. The mere discovery of new form, known and substance, which does not result in the enhancement of known efficiency of that substance. Already told actually, the last slide. New use for known substance, it is also not patentable. It means second or third use for known substance cannot be allowed. Mere use of known process, machine or apparatus is not patentable unless such known process result in new product or employ at least new rectrant. Use of food packing machine for packing talcum powder. Example, already it is available, so it cannot be. Methods of agriculture or horticulture, cultivation of oil, mushroom preparation, improved soil. However, agriculture equipments are patentable. Any process for medical, surgical, curative, prophylactic diagnosis, therapeutic, or the other treatment of human being or similar treatment of animals to render the treat disease to increase their economic value of that product. The removal of cancer tumor, surgical process relating therapy method, vaccination, you cannot. Plants and animals in whole or any part thereof other than microorganism, but includes seeds, variety and species and essentially biological process for production propagation. Mathematical methods, business method, algorithm, computer programs, it cannot be patentable. Wherever computer algorithm, business method or mathematical method also can be copyright. A literally dramatic, musically artistic work cannot be patentable, but this can be copyright protection. Some of our invention from our lab actually, this is thermal screening system method actually. It is already patent we got actually. This is the final certificate, patent certificate from Indian government. Date of filing 20, so from 17th June to 20 years. This is the patent for this application. This is the publication of the patent. Date of filing 17th June 2020. Published 7th July 20. After examination, that is granted. This is another photovoltaic cleaning and cooling system also we developed. That is also not granted yet. This is actually under examination process. This is another actually invention that is written actually. Certificate of registration of design. This is design. Design patent we can call, we can tell also. That is vegetable and fruit washer. This is design. This is Australian innovation patent actually. This is the certificate from Australian government, Australian IP. This is from 8 years from 23rd November 2020. This is innovation patent. This is short term period. This is also one Australian patent we filed and granted also, that is solar house. This is the many example of actually Australian patent. This is the German patent. It is actually written in German language, name only in English, name and date. Or in government level also, one corporation working on technology transfer exports from different academic institution to individual working on patent or different research organization working on invention. They after granting or they are facilitating for patent. After patentable, they also helping on commercialization. That is technology transfer export. Then patent examiner, trademark examination, every government has set up a IP, intellectual property, India intellectual property was like this. So patent examiner, trademark examiner are appointed by proper examination. They can check actually different resource available for them, so they can easily check novelty and other applicability. Patent trademark agent or attorney for facilitating also, it is a facilitating agency where can evaluate the what is the strength of the invention. If the invention has a strength, then it will be suggest to file the patent, and they are drafting also. They are designing patent search agent also, working on patent prior art search for searching the what is the your invention prior to search. This is the thank you all. If any question, you can ask.
Thank you, sir, for your presentation. Now we may have any questions from audience.
One madam actually asked one question, sir, can we patent algorithm we proposed earlier, which is already copyrighted? No. If already algorithm existence, we cannot. But if you adding any features in that particular algorithm or modified, we can. Patent cannot be actually, sorry, algorithm cannot be patentable. Algorithm can be only copyright.
And if you are making any changes to the algorithm, that can be copyrighted.
Yes, yes.
Okay, I guess that would have answered your question, Madhuri ma'am. Any other questions from the audience? No questions from the audience? Okay, so I think, sir, we can. Hello, am I audible? Hello?
Yes, yes, yes.
Oh,
Yes,
sorry,
ma'am.
something happened to my network. Something just keeps happening to this router. Okay, very sorry. So we learned a lot about patents in academics today, and we learned a lot of interesting things, and we got deep insights into this area, and we also got got to know about different aspects of how to file patents and what are the different steps and how your project should look like if you are to file a patent regarding it. I'm pretty sure this precious knowledge that Mr. Acharya gave us will help our scholars and students and also our teachers in our future research and our studies. Once again, I'd like to thank Mr. Acharya for taking out the time from his busy schedule and enlightening us. Thank you so much, sir. I would also
Thank
like
you,
to.
madam. Thank you. It is my
Yes, you're
pleasure
most
to
welcome.
talk with this seminar. Thank you.
Most welcome, sir. I would also like to thank our head of the department, ma'am, Professor Dr. Debahuti Mishra ma'am, and assistant head of department Dr. Sarda Prasanna Pati sir for facilitating, and Dr. Madhuri Rao ma'am and Dr. Divya Sundar Das sir for organizing this webinar session and inviting Mr. Acharya here. Also, I would like to thank all my students present here for paying attention and learning. This will definitely help you in your future. If you have new ideas, novel ideas, you can definitely patent them, and that would add a very good, nice feathers to your career cap. Having said that, I would like to end my speech here. Thank you all once again for joining. Have a great weekend.
Thank you. Thank you. Dr. Manas Pradhan also joined from UAE actually.
Okay,
He is
that's very
my
nice.
teacher also, and he is working with us also in many patents. Dr. Pradhan
Okay.
also here. Thank you.
Hello, sir. Hello, Dr. Manas Pradhan. So, thank you for joining us, sir. And I hope, and I'm very glad that you liked the session. Um,
Thank you very much. It was very informative and nice session.
okay, okay,
Thank
sir.
you. Thank you.
Thank you. We
Ma'am,
have Mr.
can
Acharya to
I
thank
just
for
say one
that.
thing? Like, Biswaranjan sir,
Yes, please.